This is the Standing Committee on Citizenship and Immigration, meeting number 23. We are studying Bill C-24, which is an act to amend the Citizenship Act. This meeting is televised. We have three guests, representatives from the Canadian Bar Association, Christopher Veman, Barbara Jackman, Carrie Frock. Good afternoon to you, and thank you for coming. We have Robin Seligman, who is also a lawyer. This is Lawyers' Day. And we have from British Columbia on teleconference, Richard Curlin, who is well known to this committee, and he is also a lawyer, so you'll all have to be very careful what you say today. Ms. Jackman, are you speaking on behalf of the Bar Association?
Yes, I am.
You have up to 8 minutes. Thank you for coming.
I'm going to start.
Thank you, Mr. Chair, and honourable members. The Canadian Bar Association is pleased to appear before the committee today to address Bill C-24, Strengthening Canadian Citizenship Act. The Canadian Bar Association is a voluntary association of 37,500 lawyers across Canada whose primary objectives include promotion of the rule of law, improvement of the law, and improvement to the administration of justice. And it's in the spirit of this mandate that the members of our immigration law section have made the comments that we've submitted to you in writing, and we will speak to you today. Chris Veman, an executive member of the CBA's immigration law section, and Barbara Jackman, a member of the section, are here with me today, and I will now turn things over to them to address the substance of our comments on the bill.
We all share the goal of strengthening Canadian citizenship, and in the CBA's view, a full public debate is very important on this topic. We understand that the last time there were significant amendments to the bill to the Act in 1977, the government published a white paper, and there were cross-country forums organized to make sure that all citizens of Canada were able to be involved in the discussion. We would encourage the government to consider a similar approach in this case. Many of the proposals in the bill come out of the blue in some respects, and we're kind of reacting without knowing the true rationale. I'm going to talk about two of the topics that we covered in our submission: the grants of citizenship, and also a particular aspect of that, the intention to reside in Canada. In general, the CBA is of the view that this bill, which is entitled the Strengthening Canadian Citizenship Act, proceeds on the assumption that by making something harder to obtain, you increase its worth. The CBA takes the view that citizenship is a bundle of rights that should be assessed on the rights that it gives to the holder. Simply making it harder to obtain doesn't make it better. So Bill C-24 does make it harder for people to become citizens of Canada. But in the CBA's view, it doesn't actually enhance the rights that accrue to citizens. In fact, the CBA takes the position that the bill diminishes Canadian citizenship by focusing solely on administrative efficiency in determining citizenship applications, reducing appeal rights for people involved in citizenship matters, and in the topic that my colleague's going to discuss, permitting the possibility of banishment of Canadian citizens. In terms of grants, Bill C-24 focuses on efficiency in the handling of citizenship applications. Unfortunately, in the CBA's view, this efficiency is achieved at the cost of the Canadian values of discretion and compassion. The only residency that's recognized under the bill is physical presence in Canada. In our submission, we point to a number of examples that are published in the CIC's Citizenship Processing Manual, CP5, which show the types of situations that, in the CBA's view, merit consideration for citizenship applicants. As an example, consider a young permanent resident who wins a Rhodes Scholarship and is off to study at Oxford. If that Bill C-24 might force such a person to forsake the opportunity offered by the scholarship or their citizenship application. I want to talk briefly about the intention to reside requirement. As you'll see in the submission, the CBA has concerns with this provision. First of all, contrary to the rest of the thrust of the bill, it's the CBA's view that this will complicate the adjudication of citizenship applications. Trying to determine someone's intention at the time of application is next to impossible. The other problem that this provision creates is a discrimination between natural-born citizens who have no obligation to reside in Canada and naturalized citizens. Now I'm realizing that I'm almost already out of time, so I'm going to turn it over to Barbara.
Okay, I'm going to cover the revocation of citizenship. Someone will have to tell me when I'm out of time. First of all, there's 3 points I want to make. Taking away citizenship from someone born in Canada because they may have dual citizenship and have committed an offense that's prescribed by the Act is new. That's a fundamental change. What it is for people who are born here, it can, if they've grown up here, result in banishment or exile. It's a step backwards, a huge step backwards, and it's a huge step being taken without any real national debate or discussion about whether or not Canadians want their citizenship amended in that way. When we teach our children in our schools that Section 3 of the Charter gives a citizen the right to vote in an election, Section 6 gives citizens the right to live, to enter, remain, and leave Canada freely, we don't tell them that it's just a matter of statute, that when Parliament's upset about something young Canadians may do, because this is directed at young Canadians who've committed offences in other places, that because they don't like what young Canadians do, they're going to change citizenship and take it away from people. That's fundamental. That's a fundamental different concept of citizenship that needs to be addressed, that needs to be discussed and debated. I think, or we think, that it could raise serious human rights concerns. It does raise serious human rights concerns. It may well contravene the Charter. The Supreme Court of Canada has already ruled in the past that we can't exile Canadians. So by redefining who a Canadian is, you achieve exile. That's not right. It's against the Charter. It appears to be against the Charter, and I expect there will be significant litigation. Another problem with it is the fact that it's retrospective, and then another problem with it yet again is the fact that it only affects persons who may have citizenship in another country, persons who will have to prove that they don't have citizenship in another country, even if they don't actually have a passport from that country, so that people who can't claim citizenship through a grandparent are safe from being exiled. People who may be able to claim citizenship through a parent or a grandparent aren't. They'll be exiled from Canada. In that sense, it also may breach the Charter in the sense that it discriminates against people based on the nationality laws of another country. One of the other problems is the grounds for the loss. Am I over the 8 minutes?
Left.
Okay, 1 minute. The grounds for the loss are very broad. You just have to look at the Canadians that took the Greenpeace boat, that were acted for Greenpeace climbing on the Russian trawler. They were charged with piracy and hooliganism, carrying 5 and 15-year sentences, or 7 and 15-year sentences. They could be stripped of citizenship if they had access to another nationality. That's not sufficiently serious to take away citizenship.
That's it?
Well, I thought my time was up. If I have more minutes, I got one other
No,
point.
you got about 30 seconds.
Okay, well then the minister, you shouldn't take it away from the courts. There's no independent and impartial decision maker in this process. To take citizenship away from someone is a fundamental change. And to give it to a minister, a politician, to make that decision without any kind of fair process is simply wrong.
Thank you. I've never seen a lawyer waste 30 seconds. Ms. Seligman, you are next, and you have up to 8 minutes.
Okay. If you can give me some warning.
I'll do my best.
Okay. Thank you very much. I very much support the Canadian Bar Association's position. I'll try and elaborate on some of the points that we're not able to because of time constraints. We're very concerned, and I'm very concerned about this serious change in direction of citizenship. It makes citizenship more vulnerable and totally insecure. Once again, please remember this impacts people born in Canada. So people who have never lived in another country but might, through relatives or grandparents, have a claim to citizenship via a relative. Looking around at the names in this room, I can tell you that most people here probably have a claim. It affects people that have Italian parents, British parents, UK parents, Chinese parents, and a particular concern is that every Jewish person in Canada has the right to move to Israel and claim Israeli citizenship. So in effect, and I provided materials of the right of law, the law of return, every Jewish person in Canada can be impacted by this legislation because they could claim status in Israel. Of particular concern to me as well is the reverse onus that this legislation puts on the person to prove that they would not become stateless. So I ask that you look at Section 10.4, which specifies this. Also, there's no appeal rights. They only talk about a leave for judicial review, and if I have time, I'll talk about what that means. To be honest with you, if a person gets a parking ticket in the City of Toronto or probably anywhere in Canada, you would have more judicial rights and appeal rights and the right to a fair hearing than you would under the citizenship as proposed under C-24. So as a parking ticket holder, you have a right to a fair hearing. Under the Citizenship Act, as proposed, there is no hearing. It is up to the minister to decide whether there's a hearing. This can be very political, and it should be definitely taken out of the hands of a minister to make these decisions. As well, there's no discretion. There's no humanitarian and compassionate review or allowing a decision maker to review the full circumstances of the case. The legislation appears, as Barb said, to be focusing on young Canadians who have committed acts that seem to be heinous. However, if you look at the definition of terrorism under the Criminal Code, it's very broad. It includes funding. It includes giving money, giving a donation. For example, right now we see Mohammed Fahmy, who is in Egypt in jail, the journalist. He would be caught under these provisions. He's been charged with terrorism in Egypt for helping put the Muslim Brotherhood's position through reporting through the news. This would be covered under our legislation. Do we really want this type of thing to happen? Is this what we want citizenship to be valued at or not valued at? So I respectfully submit that I don't think if you've read the legislation, read the details, that you may not fully comprehend how broad the provisions are and how many people they'll capture. And I clearly don't think that most Canadians would understand this. So I fully support proper debate and discussion across Canada about this legislation and the broad ramifications. Because as I said, probably almost everyone in this room or their children or grandchildren would probably be affected because they might have a claim to a citizenship in another country. So it doesn't only affect those that are citizens of other countries now. If they have a claim based on the laws of another country, then they would be affected by this legislation. And once again, it's very broad in terms of terrorism and the offenses that would qualify under this act. Do I have more time?
Yeah, 5 minutes.
Oh my goodness! Can I hand it over to Barb? I can go on.
Am I encouraging you?
No. Again, the proposed grounds of citizenship can be grounded in political contexts where in many countries allegations of terrorism are used to punish political opponents. They're facilitated by low thresholds for convictions, and unfair trial and harsher sentences can be applied. All you have to do is equate it to the Canadian law, which, as I said, Mr. Famy's charges would be equatable to a Canadian charge under our legislation, and you're caught by the legislation. Once again, the minister may have a hearing or may not. I said I would discuss the appeal rights. So under the legislation as proposed, you would have to get leave to appeal to the federal court, which means permission to go to court. I would like to explain the difference between what an appeal is and what a leave for judicial review is. A leave to appeal, which is a very difficult test, and only 15 to 20% of the cases in federal court are granted leave, is a very legalistic test based on errors of law and judicial oversight. The federal court judge cannot substitute their decision, they cannot receive new evidence, and they can't make any findings on humanitarian grounds. So it's a very legalistic paper process. It has nothing to do with a full appeal based on the bona fides, based on new evidence or other circumstances surrounding the case. There's no in-person hearing. The lawyer or the person concerned can only make in-writing submissions on leave to appeal. So I think it's very important that this committee understands there is no review, because I've heard government workers say, well, it can be reviewed at the federal court. It's leave to appeal, which is very limited in scope and doesn't allow for any substantive review of new evidence and doesn't allow a substituted evaluation, whereas an appeal would allow that. So the provisions, as I said, a parking ticket would give you more rights in court than these provisions. Today, for example, in the newspaper, the Toronto Star, Ottawa has declared the charity organization a terrorist organization. It's called IFRAN. This is an example. That was an organization, the International Relief Fund for the Afflicted and Needy, where many Canadians have donated to that charity. And if you had donated to that charity, if you want to take a broad perspective of what terrorism is in Canada, you could be caught under the provisions of Section 83 of the Criminal Code to have funded an organization. This organization provided money in terms of the humanitarian wing for helping children and the needy. Again, this is an up-to-date example of the type of provisions which maybe this minister would consider under these provisions to be categorized, but we don't know going forward if somebody else in the future may consider this type of activity. Again, funding, donating money would be covered under the provisions of terrorism under the Act. So this is an example out of the paper today. And as well, there's the 5-year for terrorism is specific only to a sentence for terrorism. All other sentences under the legislation talk about life sentences. The 5 years is only limited to terrorist attacks inside Canada or overseas. And as we can see from many Canadians that are overseas dealing with these types of situations, usually the penalties would be much greater than 5 years. So 5 years is almost a slap on the wrist for this type of activity, and it should be seriously reconsidered. I'm good.
You're good.
Thank you.
Thank you, sir, madam. Well, Mr. Curlin, welcome back to the committee. I'm always pleased to hear your presentations, whether we like it or whether we don't like it. It's always very good. You have up to 8 minutes, sir, to make a presentation to us.
Thank you, Mr. Chairman, and I'm delighted to appear, if remotely, before the Honourable Committee. With apologies, I could not be physically present. Having said that, I'd like to focus on and highlight the dramatic, pragmatic, positive changes to the Citizenship Act and point out a systemic design fail in a portion of the Act that may have unintended consequences. So what is most pleasing is the requirement to file a tax return. This is a game changer. Families can plan in advance economically what it means to receive and maintain Canadian citizenship. The duration of 6 years, given the lifetime commitment to Canada, is reasonable and overdue. Requiring 4 years on 6 years with minimum 183 days in a year for 4 years on those 6 years cuts a Gordian knot. For the first time, we have a pragmatic, transparent threshold to access Canadian citizenship. That is long overdue. Now, there is an issue, a design flaw that I would like to point out in Section 10(3)(a), and I'll read the relevant portion. Before revoking a person's citizenship or renunciation of citizenship, the minister shall provide the person with a written notice that specifies A, the person's right to make written representations. That's insufficient. The person's right to make written and oral representations. How is it that to revoke refugee status, the person is entitled to an oral hearing? How is it to revoke the status of permanent resident, the person is entitled to an oral hearing? A citizen has no right to an oral hearing when faced with revocation? That's a design flaw. And I would respectfully point out that Ms. Jackman, Ms. Seligman, and others may not be far off point when they illuminate the strength of the Charter to defend individual rights confronted with this situation. So that's really the heads up. It is an easy fix. It is a quick fix. But on the whole, we got it right on this bill. And I'll donate the time to questions subsequently.
Here they come, Mr. Curlin. Mr. Opitz is first.
Thank you, Mr. Chair, and through you and to our witnesses, thank you all for appearing today. I truly appreciate it. Richard, I'm so used to seeing you sitting at the end of the table, not on a TV screen. I don't know how I'm going to manage, but we will, I think. Folks, thank you again very much for your submissions. Christopher, you gave some examples at the beginning. Listen, my parents came here at the end of the Second World War from very trying circumstances, and it wasn't easy for them to get citizenship. Back in the day, you had a 2-year contract. You were given a job for 2 years, and you had to do it. And oftentimes, especially Allied veterans, were taking over jobs that were previously vacated by former prisoners of war. It was rather galling, quite frankly. But they managed. They stuck it out, and they carried on. And quite frankly, my parents have valued Canadian citizenship. They're 94 and 87 respectively, and they've never been prouder to be Canadian citizens, which they've all imparted on us. Yes, I was born in this country, and I'm very proud to have been born in this country, and I've served this country for many years in the military. So when we have provisions, by the way, that allow those members who are permanent residents serving in the Canadian Forces to fast-track their citizenship, I think that is just the absolute right thing to do for people who are prepared to put their lives on the line for Canada. But where this bill, and so I think putting in provisions that allow people to earn their citizenship and understand the value of being a Canadian makes a lot of sense. To use Richard's words, it's pragmatic, it's dramatic, and people have to understand that value. We have a Discover Canada guide that tells people. First of all, we talk about people committing offences in Canada. They shouldn't come to this country to commit offences in the first place. It's in the Discover Canada guide. You don't immigrate to be a criminal in somebody else's country. Sometimes people do, and maybe with that intent. But this is something that very clearly we should take to heart. And that Discover Canada guide that we built up, our Conservative government, to clearly tell people what is acceptable, not acceptable in this country, how to vote, what our procedures are, what our democracy is like, is a very clear guide, I think, for people to follow. And when this bill was created, by the way, it was vetted through the Justice Department, very, very clearly by a lot of lawyers. But Richard, I take your point on Section 10, and that's obviously now part of the record, and I think that's going to get examined back from us. But just a couple of questions to you, so I don't go off and eat up all of my time. Listen, a common misconception of the bill is that the intent to reside provision is unconstitutional. And on Monday we had Minister Alexander, who was before us, and he confirmed that the bill had been checked not only with the legal team at Citizenship and Immigration Canada, as I just said, but of course with the Justice Department. And I know that you particularly support the aspect of the bill of defining residence in the law. So do you believe that by defining residency in the bill, that not only strengthens the value of Canadian citizenship, but also ensures that residency fraud is reduced and, if not eliminated entirely? Your comments, sir.
That in spirit is precisely the direction to be taken. I have some concerns regarding the process. It has been pointed out that the shortcomings of the absence of an appeal is something to be seriously considered as well. Intent to reside is one heck of a slippery phrase. At what point is it measured? What if circumstances change? And who will be making this decision? Will the person concerned have the right to make representations in written form and orally before the decision maker? I would just point out the value of having Ms. Jackman present. That's the lawyer who was unsatisfied with the absence of an oral hearing for refugee determination. And we know what happened after that in the Singh decision. So yes, we're on the right path. We have the right spirit. The intention is good. But The purpose of a standing committee is to fine-tune the letter of the law to meet those objectives, and that's what we're doing now.
We discussed in public the new decision-maker model, going from 3 steps down to 1 step. Pardon me. How will this drastically, in your view, improve processing times? And the second part of that question is it therefore important that this bill gets passed as soon as possible in order to ensure that those in line get those faster processing times?
Well, I think that those in line should abandon their applications and apply under the new system where they satisfy physical presence requirements. Be first in, first out. Yes, the tools needed to expedite citizenship processing are now present in the proposed legislation. I can see operationally processing times reduced from the present 4-year zone to under 18 months. So as well, people forget, because of the elegant simplicity of the residence calculation, you're entitled to use as human resources individuals at, with due respect, a lower pay grade to do the math in particular applications. So we can do more files faster for less money.
1 minute, Mr. Robert.
Okay, just quickly, we've cleaned up a lot of the messes of the past years, and of course, our Liberal friends in 1947, when the Act was introduced, over the decades, had a lot of ineligible Canadian citizens. But I think we fixed a great deal of that. So. Part of this legislation will also ensure that the remainder of the lost Canadians are granted citizenship. Do you have a comment on that?
Yeah, people who are stuck and truly believe in the democratic process that we have in this country should bear by way of example the lost Canadians. It took time, it took resources. Justice has been done. Congratulations to the lost Canadians.
Mr. Roberts, Madame Blanchette-Lamouth.
Oui, merci, bien sûr, merci.
Thank you, and I'd like to thank all of you for being here with us today. First of all, I'd like to go back to what the Minister said before this committee last Monday. He said, and I'd like to quote, "We believe that this bill," talking about C-24, "is entirely compliant with our Constitution." The Minister seems to be convinced that this bill is constitutional. And I'm wondering if you have any doubts concerning that statement made by the Minister.
Je n'en vois aucune.
I don't see anyone. Would the Bar Association have any comments on this subject?
I would just remind the committee that they've passed other legislation that again and again and again the Supreme Court of Canada has struck down just recently. So the fact that the Department of Justice and the Minister says it's constitutional doesn't mean it is. And I think that you really have to question when the Supreme Court in a case called Chu, in the last, one of the more recent decisions of the court, questioned whether or not it was fair to have a single official taking away a significant right. You've got the Minister who is going to act on political grounds to take away citizenship from someone born in Canada because of an offense. It will be selectively used, and it will be used in an unfair way. You can't expect a fair, impartial, and independent hearing in front of the Minister who is the political advocate of this kind of stripping people of citizenship. He's not going to be a fair decision maker. You've got to have a court.
Madame Seligman?
Yes, I fully agree with that. I think that you will find that this will obviously work, if passed in its present form, it will work its way to the Supreme Court, obviously. Again, I'd like to remind this committee, because I think one of the members just said, people read our guide and we tell them if they come here and commit crimes, they shouldn't be allowed to stay here. But again, please be aware, this affects people born in Canada. It affects your children, your grandchildren, and you. Again, just by looking at the names on some of these, our names, probably 75% of the people in this room have people, ancestry from people that were born abroad, and they may automatically have citizenship in those countries without doing anything. you're affected. So please, that can't be compliant with the Charter, notwithstanding the advice that the minister's getting. Thank you.
Merci. Monsieur Curlin, est-ce que vous avez quelque chose à ajouter?
Thank you. Mr. Curlin, would you have anything to add to what the minister said about the constitutionality of this bill? Notwithstanding what the minister and the Department of Justice have said, I do believe that indeed there are some gaps. The lack of the right to appeal or the possibility to appeal is very important, and certainly judges will very strongly think and reflect on this. It seems to me, and I don't share the legal opinion of the Department of Justice. The minister, however, I believe is not a member of a bar in Canada, and so his mandate is limited to politicized decisions or political decisions. And yes, thank you. Concerning exile, I think that Ms. Seligman and the Canadian Bar Association, you mentioned this issue. Ms. Seligman, I'd like confirmation from maybe Ms. Jackman and Mr. Venon. Is it indeed the case with C-24 that somebody who is born in Canada could be exiled to another country where they wouldn't necessarily know the language, or if they might know nothing about that country? Could that be the case?
Absolutely. Section 10.4 shifts the onus to the Canadian-born person to prove that they would not be rendered stateless. That's the test. It doesn't talk about dual citizens. It says the onus is on you to prove that you will not be rendered stateless. And as I told you, there's many countries that if your parent is from that country and you're born to that parent, even in Canada, and even if your parent's a Canadian citizen, you automatically have citizenship. For example, the Egyptians, Chinese, Italians, etc. Many, many people of this country automatically have a right to get citizenship in another country. They would be exiled.
But, I think that we have to be careful in terms of what's going to happen here. I represented Chilean refugees through the years. Chilean government had an exile list. It kept people out of the country, citizens. It exiled them from Chile. And other dictatorships have done the same thing. What we've done is what we're doing here is more dishonest. We're redefining so that we're pretending they're not Canadians, even though they were born here, grew up here, may have lived nowhere else and have no connection to any other country. And then we're going to kick them out. That's the same as what Chile did under the dictatorship. I'm sorry, it's just too extreme. We got rid of banishment and exile in the Middle Ages. This is not the time to add it in.
Merci. Monsieur Curlin, je m'excuse. Je vais poser ma dernière question avant de vous donner la parole.
Thank you, Mr. Curlin. I'm going to ask my last question before giving you the floor. But briefly, Ms. Jackman, in our current legal system, is it not true that we have measures to deal with things such as high treason and terrorism? We can't currently deal with that in our legal system.
Punish people through the criminal justice system. We don't add additional sanctions by exiling them until now.
So now my question is to all of you, one after the other. If I understand correctly, you're suggesting that we should eliminate that section from the bill, the section that speaks of the possibility of exiling those who are affected by that part of C-24. Is that what you're suggesting? Maybe Ms. Jackman, would you like to start?
As recommended that the provision be deleted.
Madame Seligman?
Yes, I would agree with that, and as well, particular focus on children or people born in Canada. It's never been even contemplated in Canadian legislation before to deport Canadians born here.
Monsieur Curlin?
I'm not in favor of introducing the medieval law of banishment into our Canadian legal system. So on general principle, I have serious concerns. Also, the door is open in future to parliaments of other countries getting their hands on Canadian citizens. Before the Spanish Parliament now is a citizenship bill that will extend Spanish citizenship to people claiming to be Sephardic Jews. And that means that in Canada, following Ms. Seligman's train of thought, if a person is Jewish and has a certificate of being a Sephardic Jew, they get Spanish citizenship. So there are unforeseen, unintended consequences here that truly have to be studied at great length before going forward.
Mr. Sue.
Thank you. Merci, Monsieur le Président. My question is for Ms. Seligman, who brought up the contrast, the difference between a judicial review and appeal before the court, and you've talked about the limits that a judicial review has compared to an appeal before the court. And considering that this bill does deal with a very fundamental status, namely Canadian citizenship, isn't that enough to say that this bill should not rely so much on judicial review, and that Canadians should have access to the full power of an appeal before the court when their citizenship is being questioned?
Yeah, clearly. Again, I tried to set out judicial review, and again, it's permission to appeal, and it goes to the federal court. They have very limited jurisdiction. It's an administrative review. They're looking for errors of law. Was the proper procedure followed? They're not looking at the substance of the decision unless it's absolutely perverse and doesn't make sense. Other than that, it's extremely hard to get judicial review. Again, it's not an in-person hearing. You don't introduce humanitarian factors or new evidence. Under this legislation, if you are convicted, you are done, and with no right of review. You can't add in all the circumstances of your case. So judicial review would be totally inappropriate under these circumstances. There would have to be a full and fair hearing, as Mr. Curlin has mentioned and the bar has mentioned. And again, I can't reiterate, a parking ticket has more rights than C-24. You get your day in court. I provided you with the materials.
A question perhaps for Ms. Jackman. The intent to reside requirement, it could create two classes of citizens. One class who are natives and can leave the country freely, and another class who are naturalized and whose citizenship perhaps could be revoked after it's rewarded because the evaluation of intent to reside could be reevaluated. On Monday, the Minister Alexander seemed to suggest that this was all blown out of proportion and that this requirement wouldn't result in any revocations because it didn't apply after one became a citizen. But I think from what I just said, that this intent could be questioned after citizenship was awarded. The officials from the ministry seemed to disagree with the minister later in the meeting on Monday, and I'm wondering if this intent to reside requirement, could it really only be a symbolic measure and not put a new Canadian's citizenship at risk?
It puts their citizenship at risk. And the thing that I think you have to understand when officials come before you and say, well, we don't intend for it to be applied in that way, is that they have no control over what people do in the future. So if the legislation permits it, it can happen. And in fact, it does. I mean, we received so many promises from officials in the past that legislation wouldn't be interpreted or applied in a certain manner, and then it was. I mean, you know, the membership clause, for example, it is so broad it covers women who raise their children, who helped their husbands who were members of Parliament, and those members of Parliament were considered to be too close to a terrorist organization. Like, you don't get the wives, but they do now. That's how broad it is. They promised it wouldn't be like that, but it is now. So you can't bind anybody by that.
Okay.
By that.
Very different question. The Globe recently raised something I think is pretty serious concern. There's been several occasions where the United Kingdom has had citizens stripped of their citizenship, and then subsequently they were killed in U.S. drone strikes. And officials have admitted that they were perhaps using the same intelligence, the same information, the same data. What concerns does anybody have, any of the witnesses have, about mixing of intelligence for military use and used in citizenship decisions?
I think to be fair to the British system is the minister there can take citizenship away in the absence of a conviction. So they are acting on intelligence. As I understand our legislation, it'll be taken away if there is a conviction, although it could still be they could still be acting on intelligence. But it's a real concern if they are sharing intelligence, if they're sharing it in a way that allows the Americans to think that if we've taken citizenship away, just like with the United Kingdom, that they can then turn their drones on people. That is what's happened.
Okay, and I understand.
Less than 30 seconds.
Okay, there are certain organized armed groups that one can be connected with that you don't require a conviction, right? So there's data there in citizenship
Sorry, you're right.
operations.
Engaging in armed conflict against, you're right. It doesn't necessarily require a conviction, so it can be as broad as the British. That's a real worry because it has happened that a number of people have died.
Thank you, sir. Mr. Daniel.
Thank you, Chair, and thank you, witnesses, for being here. And as we know, that the Minister was here in the last session on Monday, and the Minister was quite clear not to take the revocation decision lightly. He would take it into consideration, factors and evidence, consideration other factors and evidence. Also note that criminals are the only ones being revoked of citizenship. It's not every citizen is being revoked. Criminals obviously not welcome in this country, particularly those who commit acts of terror or treason against this country. Please also note that some 86% of the caseload cases for revocation are residency fraud. It's not the terrorism or any of those sorts of things. So on Monday, the Minister Alexander discussed with us what he was hearing from stakeholders and local constituents and Canadian citizens across Canada. He explained that they like the residency requirements because it strengthened the value of Canadian citizenship. He also said Canadians appreciated that those who committed acts of terror or treason against this country would have their citizenships revoked on the grounds that they are dual citizens. Can you tell me what you've been hearing, Mr. Kurland?
Yes. Well, to be forward-looking and not rear-view mirror the discussion, I need to underscore the practical importance of the Canadian income tax return when it hits residency fraud. People will be Al Caponed instead of processed as an intent to fraud case. The reality is that given it's going to take 6 years for eligibility and the highly motivated, well-resourced Canada Revenue Agency enforcement staff, if there is a residency fraud issue, on receipt of the application, the next send button pushed will be over at CRA, and that will take care of the large volumes of residency fraud cases, I anticipate. For residency fraud, in the past it was an issue. Don't forget, we've upgraded the technology. There's now a matrix of information sharing agreements between departments, agencies, governments, foreign and domestic. So now we have the tools to lay this issue to rest. I do have concerns when it comes to intent. It's expensive case-specific adjudication that's time-consuming and burdensome to the taxpayer. The same result can be achieved with a letter from CRA and postage.
Indeed. So do you agree that the value of the Canadian citizenship will be strengthened through this important legislation?
Yes, exactly. And that's why we need to strengthen the importance of Canadian citizenship when it comes to the process of detaching a person from Canadian citizenship. If it's hard to get, it should be hard to take away.
Okay, thank you. The Minister also explained on Monday that by adding these provisions of revocation to the Citizenship Act, it will better align with the Immigration and Refugee Protection Act. The IRPA, someone convicted of a crime or someone who committed an act that would have been a crime in Canada, is inadmissible to Canada as a visitor. What's being said? Why should these criminals be allowed to become Canadian citizens?
Well, I mean, we have a criminal justice. I apologize. We have a criminal justice system to provide case-specific adjudications and determine whether a criminal sanction should be imposed. What has that got to do with immigration and citizenship? Unless you move the clock back several hundred years and tinker with the banishment process. The punishment, incarceration, and criminality is an offense separate, far away from citizenship and immigration.
Okay, thank you. Increased processing times over the years are clearly because of some of the decisions made by other governments left in the CIC portfolio, a mess for some 13 years. Not only has this Conservative government introduced numerous measures to strengthen the integrity of the immigration system and protect Canadians, but now we're doing the same through the Citizenship Bill. On Monday, Robert Orr from the Citizenship and Immigration Canada explained that processing times went up because of the increased levels of immigration over certain periods. How important is it that this bill get passed quickly with the support of all members of the House to ensure that processing times are decreased while the number of new Canadian citizens increase? So for anybody else. Okay,
I'm happy to make a quick comment. I've seen that the massive increase in processing has started in the last couple of years, and that's because the government is so focused on dealing with fraud, which is, their prerogative, but it's caused delays in all applications. Applications a few years ago, before they started this investigating all the cases, used to take about a year. Now what's happened is they've now set out residence questionnaires to everybody who's applying, even if they're short a day or two. The previous process was that they'd allow 30 days a year for holiday, and you never got into these issues. So I'd say, contrary to the information that you're talking about, it appears that the delays have started in the past few years just because of the focusing on catching the fraud. I think that residency fraud, not the other fraud, just residency fraud. And with respect to your other comments about most of the cases have been residency fraud, it doesn't mean under sections 10 under this legislation are very, very broad, dealing with any types of convictions without any types of appeal. So, what going forward will happen is not necessarily what will happen what's happened in the past will not be will happen in the future. Sorry.
Thank you, Mr. Daniel. Ms. Sitzavisen.
Mr. Chair, and I want to thank all of our witnesses here today. Apologize if you can't understand me, let me know. I want to start with the intent to reside. There's a lot of issues that have been highlighted by you folks, so thank you. And it's my understanding that this new old requirement about the intent to reside was actually in our legislation in the pre-1977 era and was gotten rid of and is now being brought back. So first of all, I'd like you to talk about why do you think we got maybe one of you might know, why did we get rid of it, and what would be the reasoning, what would be a good or sound reasoning to bring it back, if there is one. And you did speak of the fact that it creates two tiers of Canadian citizenship, and I believe that that's unfair, and I don't know if it passes a charter or constitutionality test, but if you can touch on those briefly before we move on to other topics.
I don't know why it was taken out, but it probably had to do with the fact that we live in a global community. We have Canadians all over the world doing important work, engaged in important study. I mean, there are things that you can't study in Canada. If you want to be the best nuclear physicist or you want to be the best surgeon, it may be that you have to go to the United States to do that study. This legislation prevents you from doing that. Frankly, it does. What's the point in time that you're able to leave and say, oh, I didn't have the intention? Mm-hmm. I'll tell you what they're doing with permanent residents. When they changed it in terms of people going back to their home countries, they're taking away permanent residents from people who've lived in the country for 15 years.
Right.
Because they've returned to their home countries.
So can we do a case study? I'm a naturalized Canadian citizen. I wasn't born in this country. And to do my PhD, for example, in a few years, I decide to go live in the U.S. for 5 years to do my PhD. Does that mean that I technically could have my citizenship revoked?
They're caught between a rock and a hard place, because you're that permanent resident. You want to do the 5-year residency in the U.S. to give you some skill that you're going to bring back to Canada. You can't do it when you're a permanent resident because you'll lose your residence. You have to live in Canada for 2 out of 5 years. now you can't even do it after you become a citizen, because you become a citizen and then you go do it, you lose your citizenship because you've gone outside of the country.
Because I
so
said I
that
have an intent to
student
resign, but I
either
didn't.
immigrates to
Okay.
the United States and they get the physicist and we don't, or doesn't go and do the studies. I mean, I don't know why they're doing this. Like, we're in a world that is smaller and smaller, and they're making it more and more rigid. There's no flexibility in it. None.
And they're providing the residence requirements the 4 out of 6, and that's a decision. So isn't that enough? 4 out of 6, 183 days per year and 4 years, and tax returns. I don't think you need to look at the intent. What if the person applies for citizenship and they get accepted into a PhD program around the same time? Does that mean when they swear their application they're lying if they say they intend to reside in Canada because they might want to in the future go and pursue that education? Just seems very inappropriate in this global economy, and why would we want to limit someone to not doing that?
Yeah, so the only problem is that the minister, who is the one who's getting all this extra discretionary powers with this, actually, when he was here, said that no one would lose their citizenship because they leave the country after being granted their citizenship. So I don't know who to believe. Do I believe the minister who is pushing this law through, or do I believe legal experts who are saying that they would?
You can believe this minister. He might not do it, but the next minister will.
Right.
And if not that minister, the minister after him.
Right.
Because every single promise that I've ever seen in the 30 years practicing where they said they would not apply it in a certain way, they've turned around and done it.
And it's our jobs to make sure that we're looking at the long run.
You're looking at the wrong run in terms of what it says in the
In
law,
the
not what the
actual law.
minister says. You know,
Right.
a good case to remember? The motor vehicle reference case. Barry Strayer was involved in determining principles of fundamental justice, and he told everyone it was just due process, and the Supreme Court of Canada said, sorry, you're wrong. This is what it says, and we don't agree with you. It's up to what the courts and the other officials do in terms of reading the legislation, not this particular person.
And I guess just to pick up on the issue of constitutionality, Section 15 prohibits discrimination on the basis of national or ethnic origin. Now, the intent to reside applies only to naturalized Canadians and not to Canadians that receive their citizenship because they were born here. It's difficult to see how that distinction would survive Section 15 challenge. So,
Thank you.
Thank
Mr.
you.
Leon.
I'm out of time.
Thank you, Chair, and thank you for your witnesses. Actually, I do not quite share that the courts in the future will interpret it differently, because just all you have to do is look at the Supreme Court's decision on our constitutionality on changing the Senate. I mean, they went back to its original intent of 7 provinces and 50% of the population. So I think, you know, if the people who are charged with interpreting our laws are consistent, I think these type of situations will not happen. And as you, and I appreciate what Mr. Berman said. You know, what happens if you have a permanent resident who came here, study, and then goes to the United States or goes to Oxford to study? You know, as long as he intends to come back to Canada to be a Canadian citizen, which, as in my case, I did. I went to the United States for my graduate studies, and I came back, and, you know, it was not an issue. But then that was under a different immigration law prior to 1976. But my question, actually, I'll speak about a corollary to this. You know, in the current bill, as with the previous one on Bill C-31, what we did was that we start to regulate immigration consultants, and we start to make sure that immigrants in Canada receive sound and proper advice. And now we're proposing a similar request in the Citizenship Act now to also to regulate citizenship consultants. And, you know, I was previously in the public accounting area, and I said, great, I mean, the more legislations that the government come down with, the more you know, there is for us to work and to interpret, and it becomes sort of like almost like a work creation for us. What I want to hear Richard is, I said, how does regulating, you know, both the immigration consultant and decision consultant, how would this benefit Canadians overall, or And how does this benefit the industry overall, or are we just creating another avenue of business for all these consultants? So perhaps you can share with us your thoughts on this. And how would this also strengthen our Immigration and our Citizenship Act?
Well, having an authorized third party intervene creates added value operationally to the citizenship determination process. So on the one hand, the federal government has created a professional organization that is subject to regulatory oversight. That's a good thing. And on the other hand, it has created, in effect, a privatized vouch for system paid by the user. So procedurally, I see advantages to having authorized third parties. You're mentioning immigration consultants. This would include members of the bar and Quebec notaries as part of the package. In connection with the overall, what we have perhaps omitted in our discussion in the last hour is what's not in this proposed legislation. What we do not see here is the issue of revocation of citizenship by birth. In other words, there's no attack on quote-unquote visa babies, anchor babies. And kudos to the parliamentary system for not including that aspect in this law. That, I suspect, was the missing piece of the puzzle connected to the intent to reside provisions. Gladly, happily, the citizenship by birth issue is not before us today, and I will maintain the fight against such an introduction now, as I have in the past, as I will in the future.
On that same issue, Mr. Kernan, the birth on soil, with the intent, say 100 years ago, was that it was very difficult to arrive in North America. So therefore, once you've made that arduous journey to be here, then the citizenship was sort of a natural grant, a grant of right. In the current society, current world, I mean, transportation is instantaneous. You can fly 15 hours from Asia here, and then you can give birth and go back. But I also share with you that is an issue. But so, in conclusion, your thought is that the third-party vouching by citizenship consultant, by immigration consultant, is a good feature for this act.
Yes, it is a good feature. Many professionals choose between two paths. One is my client has the right to a process, and the other is they stand and examine the contents of the client's application. But yes, indeed, sir, I see no harm here, only benefits to Canada, the applicant, and of course the business case for the consultant.
Thank you very much, Mr. Curlin. Our time has expired, and I'd like to thank the representatives of the Canadian Bar Association and Ms. Seligman. Mr. Curlin, don't ever change. Don't ever change. Thank you very much. You've all been very helpful, and we appreciate your comments. We will suspend. We have Mr. Matis here from the B'nai B'rith Canada, who's the, I guess he's a lawyer too. And we have Debbie Douglas, who's with the Ontario Council of Agencies Serving Immigrants. And finally, by teleconference from British Columbia, we have Mr. Martin Cullicott, who is with the Centre for Immigration Policy Reform. All three of you have been here before, and I welcome you on behalf of the committee. And you each have up to 8 minutes to make a presentation. We'll start with you, Ms. Douglas.
Thank you very much. Oops. Thank you very much. It's good to be back to speak with you about C-24. The bill, as you know, was introduced on February 6, 2014, and the Minister of Citizenship and Immigration at the time said that the bill is meant to reduce citizenship fraud, increase efficiency of the system, and reduce backlogs. At OCASI, we believe that the bill is likely to exclude more people from citizenship by making the process more difficult. We are especially concerned that the bill diminishes the value of Canadian citizenship by treating differently those who have dual citizenship and those who don't, between Canadian-born citizens and naturalized citizens, and between immigrants who do not work in the Canadian Armed Forces and those who do. The bill gives more power to the Minister to revoke citizenship and reduces judicial oversight. We are particularly concerned about the impact on racialized immigrants and refugees and on immigrant and refugee women and children. I wanted to remind us that this year marks the 100th anniversary of the Komagata Maru and the 75th anniversary of the SS St. Louis, a reminder of Canada's history of shamefully racist immigration policies. Changes to the Citizenship Act must work to undo the racist policies of the past by welcoming newcomers, bearing in mind that the majority of new immigrants and refugees today are people who, 75 or 100 years ago, would have been deliberately excluded from Canada. We believe that in discussing this bill and in moving forward with our discussions, there are certain principles that we must pay attention to. The Act lays out citizenship rules and thus defines who is Canadian and who we are as a country. This important legislation must therefore incorporate the following principles. Respect for the principle that all citizens are equal. Respect the principle that citizenship is a status from which rights derive and is thus similar to our status as human beings. It is not something that can be lost through bad behavior. We must ensure that the legislation is consistent with the best interest of the child. And we must recognize that some permanent residents face systemic barriers to full participation, including refugees who have suffered persecution and long years of deprivation. I'm going to touch on a number of clauses in the bill that we wanted to respond to. The first, longer periods of residence in Canada before applying. Bill C-24 would require applicants for citizenship to have lived 4 out of the last 6 years in Canada, compared to 3 out of the last 4 under the current law. It will no longer allow applicants to count time in Canada before becoming a permanent resident. The change will result in making people wait longer before they can qualify to apply for becoming a citizen, undermining Canada's stated commitment to integrate newcomers. Becoming a citizen is particularly important for refugees who have no other country they can turn to. Until they are citizens, they have a sense of insecurity and face practical problems such as difficulty traveling without a passport. Certain permanent residents will be disproportionately affected, such as refugees and living caregivers. Racialized women are overrepresented among living caregivers, and many typically endure years of exploitative working conditions. Not being allowed to count time spent working in Canada as time to qualify for permanent resident status will further disadvantage these individuals. Other permanent residents, such as those who qualify for Canadian Experience class, including international students graduating from Canadian universities, will also be disproportionately impacted by this change. And in Ontario, over and over, I've been hearing from international students that part of the drawing card to come to Canada for school is because there is a pathway to permanent residency and then to citizenship. We have 2 recommendations here. Keep the period of residence to 3 out of the last 4 years, and keep the rule allowing applicants to count at least 1 year in Canada before becoming permanent residents. Intention to reside in Canada, and I know the last panel spent some time on this. The fact that applicants for citizenship have to swear an intention to reside. The provision will apply only to naturalized citizens, thus creating a different and less inclusive category. Their mobility rights will be in jeopardy for fear that their citizenship might be revoked for misrepresentation or fraud, while those born in Canada will have the ability to travel freely and pursue education or work opportunities overseas. OCASI has heard that a growing number of immigrants return to their country of origin or travel to another country for employment because systemic barriers in the Canadian labour market have made it difficult to find suitable employment here at times. Many others have returned for a period of time to meet other obligations, such as looking after aging parents, a practice that will likely increase as it becomes increasingly difficult to reunite with parents and grandparents in Canada. There is a serious risk that these Canadians would be seen as engaging in misrepresentation simply because they have to go elsewhere to make a living or to fulfill family obligations. We have one clear recommendation here: delete this new provision. Language knowledge acknowledgement. The bill greatly expands the group of individuals who must meet language and knowledge requirements in order to become citizens of Canada. Under the current law, individuals between the ages of 18 and 54 are required to meet these requirements in order to become Canadian citizens. Bill C-24 will require applicants between the ages of 14 and 64 to pass the citizenship test. Number of issues. Older refugees may be able to learn English or French to function, but may nonetheless have difficulty passing the legislated language test. Older permanent residents must be encouraged and supported in learning one of the official languages and acquiring knowledge about Canada. However, given the greater difficulties in learning a new language at an older age and passing tests, expanding the requirements to those up to age 64 will result in excluding a significant number of individuals from citizenship. Older people are generally recognized as vulnerable members of our society. Creating more barriers to citizenship will make them more vulnerable. And the rationale for extending the test requirements to applicants aged 14 to 18 is not clear. Youth at this age will be in high school and must have been in Canadian schools for the past several years. If they do not speak French or English or know about Canada, the fault surely lies with our schools. Furthermore, with respect to language testing, it is not known what proof of language ability will be accepted. The proofs currently accepted will not work for youth. Completion of high school or government-funded language classes, and there is no standardized documentation across school boards throughout Canada. The fear is that adolescents will face significant administrative hurdles to prove their language ability or face the cost of an approved language test, which can run up to $200, a cost that is often beyond the capacity of some families. By adding new requirements for youth aged 14 to 18, we risk producing a new category of youth who have spent most of their formative years in Canada but are denied citizenship and thus the possibility of participating fully in Canadian society. Our recommendation: keep language and knowledge test requirements to the existing age group of 18 to 54. And I want to add here that we've been successful in having Citizenship and Immigration Canada also recognize that passing a speaking and listening test does not work for deaf and hard of hearing immigrants. And so we were able to have an exception made where an audiology report will be accepted as an exception. And we want to applaud that move, but
Thank
we
you,
also
Ms.
want
Douglas.
to
We
see
have to
this
move
done.
on. I'm sorry. Mr. Mattis.
Yes, thank you for asking me to be here today on behalf of B'nai B'rith Canada. I'm going to talk only about the revocation provisions in the bill because B'nai B'rith Canada has a lot of experience with them. The proposed changes to the Citizenship Act in this area are a mix of good and bad news. The good news is that the government proposes to remove the defects which had hampered the effort to use revocation as a remedy for international criminal fugitives in Canada. The proposed law is better than the present law because it removes the cabinet from the process, it allows for an appeal, and consolidates revocation and removal proceedings. The old law required cabinet approval, meant that the government legal arm could win in court, and then the political arm, Cabinet, could reverse the result. This is what happened in the cases of Wasyl Lodinsky and Vladimir Katrok, who the court said both entered Canada by hiding their Nazi past. The Cabinet, nonetheless, without reason, said they could stay. The League for Human Rights of B'nai B'rith Canada, whom I represented, went to court to argue that Cabinet could do that, that Cabinet to argue that Cabinet could not do that Cabinet had to revoke citizenship. However, the court said Cabinet could do that, could let those who the court found lied about their Nazi past on entry remain in Canada. It's a relief to see the proposed law takes away from Cabinet this power which has been so badly used. The absence of an appeal meant the courts could reach inconsistent decisions on the interpretation of the law and nothing could be done about it. There was no way of straightening these inconsistencies out. The proposed law, by allowing for an appeal, means the courts can speak with one voice instead of several. The Nazis in Canada who hid their past on entry were brought to court decades later when they were much older. Their strategy was litigation to death, which mostly worked. Even those who lost their cases in court at every stage had to go through so many steps that the process was never completed before they died natural deaths. The proposed law, by cutting down on fragmentation, by providing for consolidation of two steps, revocation of citizenship and deportation into one, combats this strategy of endless litigation. It is a welcome change. So that's the good news, but there's bad as well. The bad news is that it makes citizenship all too easy to lose in cases that have nothing to do with international crimes. Right now, citizenship can be revoked on only one ground: false representation or fraud or knowingly concealing material circumstances. The bill proposes expanding the grounds for revocation. One new ground for revocation is convictions for treason or terrorism offenses. A second new ground is reasonable grounds to believe that the person served as a member of an armed force of a country or an organized armed group, and that country or group was engaged in armed conflict with Canada. For terrorism offenses, convictions can be abroad as well as in Canada. Yet terrorism is a charge that repressive regimes use against their opponents who resort to violence to attempt to dislodge them. The Universal Declaration of Human Rights provides in the preamble that it is essential, if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. So the Universal Declaration of Human Rights recognizes that tyranny and oppression can lead to rebellion. When tyrants and oppressors convict their rebellious opponents of terrorism, and the opponents are Canadian citizens, Canada should not legally be able to revoke the citizenship of those citizens merely because the oppressors and tyrants label that rebellion terrorism. There needs to be a caveat so that not any foreign conviction for terrorism can lead to loss of Canadian citizenship. The foreign conviction, if it is imposed in disregard of accepted international standards, should not be recognized in Canada. This concept of taking into account accepted international standards for convictions is already employed elsewhere in the legislation, the Immigration and Refugee Protection Act. Despite the possibility of revocation for commission of offenses, the bill is under-inclusive. It has been an anomaly that you could lose citizenship for hiding on entry to Canada Nazi crimes against humanity, but not for actually having committed those crimes. Often lying on entry is easier to prove than the commission of crimes, but not always. Immigration records may have been lost, but the proof of the crimes themselves may be readily available. Revocation for commission of the major international offenses found in the statute of the International Criminal Court, war crimes, crimes against humanity, and genocide should be possible. The crimes which allow for revocation, though, should be committed before the person becomes a citizen. Revocation for acts committed after a person is a citizen is problematic, even if one limits revocation to dual citizens, as the proposed law does. A person can be a dual citizen from birth. A person can be a dual citizen without even knowing he or she is a dual citizen because he or she is unfamiliar with the citizenship laws of the other country. We should not be revoking the citizenship of Canadians for crimes committed after the acquisition of citizenship, no matter what the crime. Once a person becomes a Canadian citizen and commits a crime, then he is our criminal. We should not pretend otherwise. The bill also proposes a new procedure for revocation and then allocates the different grounds of revocation amongst the two procedures. I have a relatively lengthy section on this, which I'm going to skip over. The government has introduced a new procedure on grounds of simplification, amongst others. But the point I try to make, at least one, is that it actually complicates matters quite considerably, which you'll see if you read through this material. It also runs the risk of the government losing cases for international criminals, which it could otherwise win simply by choosing the wrong procedure. So in conclusion, let me say that we commend the government for its consolidation of revocation and deportation, its introduction of an appeal, and its removal of cabinet from the process. We deplore the possibility of revocation for crimes committed after one is a citizen, the impossibility of revocation for commission of war crimes, crimes against humanity, and genocide, and the introduction of a less fair procedure for revocation in some cases. The possibility of revocation of citizenship for crimes committed after one is a citizen should be dropped. The possibility of revocation of citizenship for commission of war crimes, crimes against humanity, and genocide, where the crimes were committed before the acquisition of citizenship, should be introduced. The possibility of revocation for foreign conviction of terrorism committed before the acquisition of citizenship should be limited to convictions which conform to international standards. The less fair procedure of revocation through ministerial decisions, subject to judicial review in some cases, should be replaced by the more fair procedure of federal court decisions in all cases. And those are my remarks. Thank you very much.
Mr. Matas. Mr. Calicott, it's your turn. Welcome again to the committee. And you, too, have up to 8 minutes.
Thank you, Chair. Can you hear me? Can you hear me?
I can, sir.
You can?
I can indeed.
Okay, thank you. Well, thank you first, Chair and members of the committee, for inviting me to speak before you today. And I'm pleased to be able to contribute my views on this comprehensive overhaul of Canadian citizenship legislation, which in my view is long overdue. And I might mention in this regard that prior to my careers overseas with the Canadian International Development Agency and the Department of Foreign Affairs, I served as citizenship advisor to the Ontario Department of Education, and therefore have had a long-term interest in matters related to this topic. Now, my comments on specific provisions of the proposed legislation are as follows. I support the extension of the residency requirements for citizenship applications from 3 out of 4 years to 4 out of 6 years. I would have preferred that it be extended to the 5-year residency requirement, which had been in effect prior to 1977, and which I had recommended in a paper published in 2008. But I understand that compromise may be required in order to get agreement on this. It should be noted that no other immigrant receiving country, at least none I'm aware of, has as short a residency requirement as Canada does at present. Australia has a 4-year requirement, 5 years in the United States, the United Kingdom, New Zealand, and Ireland, and last time I checked it was 7 years in Norway and 8 in Germany and Switzerland. So we will still be among the shortest residency period required. Now, the argument has been made that the sooner a newcomer can get their citizenship, the more attached they'll feel to Canada. While this may be true in some instances, one hears far more often of cases of those who are interested in acquiring citizenship as quickly as possible and wish to do so in order to move back overseas as fast as possible and regard their Canadian citizenship primarily as little more than an insurance policy. If anything, I think newcomers will value their citizenship more if they know that it's not something that can be acquired quickly or without meeting certain standards. I strongly support the provisions of Bill C-24 aimed at ensuring that residency requirements are actually met, particularly in view of evidence that thousands of people have obtained their citizenship fraudulently by claiming they've spent time in Canada when in fact they had not. Bill C-24 includes greatly increased penalties for such fraud, as well as requires the filing of income tax returns in Canada and a commitment to living here. While these are all useful measures with regard to ensuring that residence requirements are met, I believe it's also important that Canada proceed as quickly as possible with plans to introduce comprehensive screening and recording of the entry and exit of all non-Canadians into or from our soil. And in this way, we'll have a much more accurate picture of whether residency requirements have been met. By the same token, I'm glad to see that the bill includes measures to speed up the processing of citizenship applications and reduce the large backlog of applications that's developed. Once someone has met the residency and other requirements for acquisition of citizenship, it's important that they receive it without delay. In other areas, I fully support those parts of the bill designed to enhance the value of citizenship, such as expanding language requirements. Ability to communicate with some fluency in English or in French if you're going to Quebec is clearly one of the key factors in enabling a newcomer to become a contributing member of Canadian society and to feel at home here, as well as crucial to their employment opportunities in this country. I'm therefore very pleased to see that the provisions of Bill C-24 recognize the importance of having a basic command of one of Canada's official languages as an essential skill for newcomers who are going to be able to contribute to Canadian society and the economy, as well as be able to realize their own dreams and aspirations as immigrants. I'd add, however, that the level required, that's Canada Language Benchmark Level 4, is still quite low, and that for immigrants hoping to find employment in many different professions and in managerial positions, significantly higher levels of competency are necessary. I equally support those sections that provide for the revocation of citizenship for those who obtained or retained citizenship on the basis of providing false information in such areas as residence fraud, concealing criminal inadmissibility, or identity fraud, as well as those who commit acts of terrorism. And as I mentioned before this committee in April of last year, there is strong public support for tougher measures revoking citizenship. A survey in 2012 found that 8 out of 10 people polled agreed that Canadians found guilty of treason or terrorism should lose their citizenship. A poll taken some years earlier by Ipsos Reid found that 3 out of 4 Canadians would support revoking the citizenship of people who'd obtained it and went on to commit serious crimes, and also found, interestingly, that 35% of respondents supported such measures even in cases where the offenders were born in Canada. That's unlikely to happen, but that gives you an idea of public support. I understand that birth certificate is not dealt with in the current bill, and that it is a complicated issue that involves the provinces and territories in as much as they're responsible for health care facilities and registration of births. Birth certificate, however, is an issue that should be dealt with a minimum of delay. It provides, what it provides for now is any infant born on Canadian soil can get Canadian citizenship, and it is known to be widely abused by people who have no connection with this country but arrange to give birth here so their children will be able to enjoy all the benefits of Canadian citizenship when they're older. And the concept of birth certificate, by the way, was developed in the United States after their Civil War in order to ensure that former slaves born in the USA would not be denied American citizenship. It's no longer needed for that purpose, however, and has been abolished by virtually every country in the world except Canada and the United States, and efforts have been underway for some time to eliminate it in the United States. Chairman, this completes my opening comments, and I'll be glad to answer any questions. Thank you.
Thank you, sir. Mr. Meningakis has the floor.
Thank you, Mr. Chair, and thank you again to our witnesses for appearing before us today and for their informative testimony. I'm going to make a few comments and ask a couple of questions. We've heard from the witnesses today, both in the first session and in this session now, some commentary on the residency requirement and language requirements and the application of those potentially moving forward when this bill is passed by Parliament. On the issue of residency requirement, question came up by a member of Parliament to a witness in this committee. It said, you know what, I'm a naturalized Canadian, basically, or who is a naturalized Canadian, who said, if I wanted to leave the country and take my PhD studies for 5 years outside of the country, could my citizenship be revoked? Nothing in this bill would prevent any citizen, Canadian citizen, naturalized or any Canadian or otherwise, any Canadian citizen. Nothing in the bill suggests that their citizenship would be revoked because they left to study in the United States or somewhere else around the world. There's no such thing written in any article of this bill, and it would be a tremendous stretch for someone to suggest, whether they're a legal expert or not, to suggest that, yes, it could be applied in the case where somebody was to leave the country to study, do a PhD at Columbia University in New York. Oh, when you became a Canadian citizen 15 years ago, we're not going to revoke your citizenship. It's just so out there and so outstretched that I think that we have to be very cautious when we're reviewing this bill, all of us here on this committee, and certainly all parliamentarians, that we don't use extreme examples that have no basis in law and actually no basis in substance in determining how we move forward in our assessment of this bill. The question of language requirements, and I'll add this now back to the necessary residency requirement going from 3 years to the 4 of the last 6 years, and achieving a level of language requirement and the language requirement age changing from 18 to 54 to 14 to 64. We firmly believe that allowing this kind of more time in Canada and developing language skills for all aspiring Canadians will give them a better opportunity. First of all, they'll be more integrated into Canadian society, and will give a better opportunity to have a much more potential for successful outcomes moving forward. And what we want for newcomers coming to Canada is we want them to succeed. We want them to do well, and we want them to have every tool at their disposal moving forward as a Canadian citizen. And that's the spirit with which this bill C-24 was drafted. And that certainly is the intent of the bill. I believe it was Mr. Collicott who said that it is in line, in fact, even more generous than some of our peer countries around the world in terms of their requirements for residency and language. There's no country that we could point to that we would consider a peer country that would have only a 3-year requirement for residency, and then you're automatically you can apply for Canadian citizenship. But I want to talk about a few things in the bill because mention has been made as to the backlog of Canadian citizenship. I believe one witness that we've heard over the course of the discourse here said that we would have the backlog has been created over the last few years because we're focusing more on fraud. Well, let's just be abundantly clear about that. If we need to take more time and do due diligence to ensure that there's no fraud in the system and not only law-abiding citizens, law-abiding people want to become citizens of our country, we are going to do that. 90% of our applications get processed and there's no issue. If we're going to focus on that 10% to make sure that only people that are in the same bracket as those 90% can come into Canada and become Canadian citizens, then that's exactly what we're going to do, because we want law-abiding citizens coming to Canada. We certainly don't want anybody that's perpetrated fraud in any way, shape, or form. And if they have, then they're not welcome to come here. In addition to that, I might add, the best way for someone not to have their citizenship revoked is not to commit the crime. It's very easy. It's very simple. One of the witnesses had the exercised the option of pointing to the names of the people around, sitting around the table at one point, and said, look at the names around the table. We could be talking about you. Well, guess what? None of the people around this table are perpetrating crimes. We're not worried about being kicked out. My name is Menegakis. It's clearly not a native Canadian name. My parents came here from Greece. If I don't perpetrate the crime, my citizenship is not going to be revoked, or my children, or anybody in my family. It's the best way to avoid not having it revoked. So let's just go back to a little bit to reality here. I have one question. Do I have any time left here?
You've got less than a minute.
I have less than a minute. I'm going to ask this question. I'm going to ask it of Mr. Collicott. Mr. Collicott, we're going from a three-step to a one-step process in the determination of citizenship, decision-making for citizenship. Can you comment on that, please?
Yes, I think that makes a lot of sense. As I said in my presentation, it's a priority that we reduce the backlog and reduce the waiting time. And there will still be I think, provision for some kind of a appeal in complicated cases to the federal court. But what the government, I think, has found is that the vast majority, or a large majority of cases, could be dealt with expeditiously and effectively through the one-step process. So I find this a rather sensible solution, which doesn't exclude some system of appeal in more complex cases.
Thank you, Mr. Collicott. Ms. Sitza-Beeson.
Thank you, Mr. Chair, and thank you to our witnesses who are here with us today. And Ms. Douglas, you had mentioned in your presentation, I really liked, I hope I got the quote right. I know Hansard would get it right, but you said citizenship is a status from which rights derive, and that's very, very true. And thank you for saying that, because it's so true, and I think sometimes we forget this. Now, you had mentioned about the intent to reside, that it creates two tiers of citizenship, and between the naturalized citizenship and naturalized Canadians and born Canadians. And you spoke specifically about the mobility rights, that mobility rights of naturalized Canadians become under question. Can you expand a little bit on that? And I know that the Canadian Bar Association, in their brief that they sent us, also spoke about that, and we didn't get a chance to talk about it, so I'd like, if you could, to expand a little bit on it.
That has been one of our biggest issue, and so by having naturalized citizens take an oath of the swearing to reside in Canada, any movement away from that subjects them, we believe, to charges of fraud. That you lied to become a Canadian citizen, and now you've left the country, whether or not to study. For in our experience, many folks are having to return to their country of origin to take care of parents and grandparents. As I said in my remarks, as we've made it more and more difficult for families here in Canada to reunite with their parents and grandparents. We have a 5,000 per year quota in terms of application, and all of the things that you know as parliamentarians. We believe that expecting naturalized Canadians to swear to reside in Canada when Canadian-born Canadians do not have to do that creates two tiers of citizenship. And I absolutely agree with my colleagues from the Bar Association who spoke before, who talked about it not surviving a Section 15 challenge.
Thank you. That's exactly what the Bar Association mentioned in their brief as well, about how Canadian-born Canadians don't have that requirement they don't have their feet shackled, basically, inside the country, whereas the naturalized Canadians do. You also spoke about the citizenship tests and the language requirements, and I know that Okazi works with newer immigrants, and you do a lot of servicing for them. I'm not sure if you have any studies that you can point the committee to with respect to older Canadians or elders in the community, and because the age requirement is going up as well, and maybe you have stats on your own clients. I don't know. With respect to language retention success for older individuals, do you have anything that you can point?
Study I can quote to you off the top of my head, but I will gladly send information once I get back. But we do know. Yes, we will. But we do know that there are many refugees in particular, and many older refugee women who have spent a generation in the camps and have had no access to formal education, and Canada has granted them protection. We believe that they have as much right as anyone else to become citizens. of this country, and expecting someone 60, 61, 64 to not only learn the language, to be functional in English and French, and I think we all support wanting people to be able to participate in their communities and to be able to speak the language, which is very different from reaching a CLB4, which Mr. Colcott I know thinks is too low a threshold, but to write formal tests, to be able to retain enough language, to be able to write a citizenship test, we believe is unfair to older folks, particularly those who have had no formal education.
Thank you. Mr. Mattes, I think you spoke about revocation mostly in your presentation. And my question is with respect to Article 8 in the, or I don't know what it's called, it's Section 8, Section 10.2, the changes that are in the new legislation with respect to revocation of citizenship for an individual who may have committed a crime of terrorism or treason in another country, where they were charged in another country for such act, and they could have their Canadian citizenship revoked. And it's very clearly articulated that it could be whether it was before or after this person was granted Canadian citizenship that they committed this and were charged this in another country. Now, my question to you is, how does this, in my mind, I'm thinking of, I can rhyme off at least 5 countries off the top of my head whose judicial system that I don't trust as a Canadian. How does it make sense that in our law we are putting into writing that we're essentially trusting that every other country in the world has a fair and free judicial system that is impartial from any type of influence? And is this what you? I know you're a lawyer. That's why I'm asking you this. Does this make sense? Is this what we should be doing? Should we? And then is it up to now bureaucrats to actually make that assessment of whether that other country's legal system is fair and whether we should accept it?
Yes, well, in fact, this was something I had addressed in my text, and it's definitely a problem. And indeed, there's, I don't see even that a standard is left for bureaucrats to assess. If you're convicted of one of these offenses abroad, then that means you can lose your citizenship. Now, we heard from a previous question or statement that the Member of Parliament said, don't commit the crime, you won't have a problem. But that's not the case with these offenses, because people do get convicted even though they don't commit the crime. And it isn't just a mistake, which can happen even in Canada. It's intentional. I mean, I see all the time, as you say, and I can name maybe even more than 5 countries where this happens, where people get labeled as terrorists and convicted of terrorism offenses, where all they have done is expressed peaceful opposition to the government in power. And the conviction, the labeling conviction of terrorism is a form of delegitimization of democratic opposition to tyrannical rule. And it makes no sense at all to say you can lose Canadian citizenship because a tyrannical government abroad opposes your democratic opposition to their tyranny.
Thank you, sir. Mr. McKay.
Continue to pursue that line, because I was thinking that in my lifetime we've gone from Irish terrorists to Tamil terrorists to Muslim terrorists, and a lot of these terrorist ideas have been, how should we say, in the eye of the beholder. There's no Tamil in Sri Lanka that can access a fair justice system, and yet there is a sense in which all Tamils in Sri Lanka are terrorists. So if Canadian citizens such as Rathika travel which you have, travel and participate in any form of protest movement, the government labels her as a terrorist. So why should she, and I'm not sure whether you are naturalized or whether you're born here, you're naturalized. Why would she be subject to, in effect, double jeopardy.
If I may say so, in my view, this is a glaring defect in the bill and needs some form of remedy. And the language is very simple, which could remedy it, because it's found in the Immigration and Refugee Protection Act already, which saying that the conviction has to be in conformity with international standards. Why not? I mean, you don't have to remove it. Just say in conviction with international standards. Because right now, it's just adding to or reinforcing oppression abroad. Now, of course, you know, you name the Irish or the Tamils and so on. There are individual cases of terrorism, and that's not the issue. The issue is that the opponents, I mean, very often in a context of civil war, there's violence on both sides, and then there's supporters on both sides. And we've developed a very broad notion of complicity in terrorism, which, you know, as long as you're kind of supportive, it's okay. And especially when you're dealing with oppressive governments that really don't care about whether you're involved in violence or not, as long as you're kind of supporting the other side. To them, that's terrorism.
If you're in compliance with international standards, whatever that means at any given time, there's no fair trials that happen in Sri Lanka.
Exactly. Well, that's what international standards mean.
But can you actually overlay any quote-unquote conviction of Sri Lankan terrorism with compliance with international standards when the state is a rogue state and is been condemned, rightly condemned in my judgment, by our own government?
Yeah, I acknowledge that there's some legal systems that are legal systems in name only, where the judges are not independent, that they take directions from the government. They may not even decide the cases in front of them, and somebody else decides them. And some of these systems, you have to question every single judgment in every single case, because the system itself is not fair.
Stretch to run through quite a raft of countries where the system of justice is a system, or a justice system in name only.
Fair enough.
And so the CBA seems to be recommending just get rid of it, because it's just going to create way more difficulties than it could possibly alleviate. I'm sure that, you know, certain Canadians are offended deeply by some activities of some Canadians.
Well, I should also say that I wouldn't say get rid of it completely. I would say get rid of it for Canadian citizens. But if you committed the offense, if you commit the offense after you're a citizen, but if you've committed the offense before you're a citizen, and it meets the test because of international standards, which I acknowledge in some countries will never happen, then I think, you know, conceptually it makes sense in that context, and they're dual citizens, and conceptually in that context it makes sense, because you will get, and indeed this happens, I mean, you will get people who commit terrorist offenses before they become Canadian citizens in Britain, in the United States, in Europe, and then they come to Canada. Yeah. And so I don't see why the law couldn't deal with that.
Okay. All right. I appreciate those comments. I must admit that in my own office, just processing the citizenships and the delays, the endless delays between your PR and your final citizenship, you know, if you could just junk this whole bill as far as I'm concerned and just fix that problem, it would solve 98% of the grief that comes with doing this. I'll end there, because I'm not a member of this committee, and I did come in late on the testimony, and I don't want to take away from members.
Well, you did an outstanding job, Mr.
Well, thank you. I appreciate that, sir.
Indeed. And you've run out of time, unfortunately.
Yes.
Mr. Shuri, it's your turn.
I'm volunteering.
Yeah.
But, thank you, Mr. Chair, and thank you to the witnesses also. This bill C-24 carries the provisions of my private member's bill, specifically when we talk about a revocation of citizenship, and also giving some credit to those who serve in our Canadian armed forces. But before I talk about that, I want to clarify some things that in this bill. Well, first of all, Mr. McKay, I want to thank you for recognizing this government's stand on humanity, on the position in Sri Lanka. So that shows that when we talk about foreign jurisdictions, criminality, we simply do not take it. When we talk about
to all members of Parliament.
when we
Shuri,
talk about-
stop the clock for a minute.
we
Mr. Shuri, you know, this isn't the time to get into a debate with members.
I'm not getting into debate, Mr. Chair. I was simply.
That was a compliment.
Okay, just please ask a question or make a statement. Thank you, sir.
Thank you, Chair. Okay, I want to start by clarifying a couple things. That in this bill, when we talk about language requirement, there is a provision of waiver on humanitarian and compassionate ground. And when we talk about criminal actions, we talk about our criminal code. So the action taken in any country has to be in the same line as mentioned in our criminal code. Now let me get back to the provisions I strongly believe must become the law of the land. So the committee has heard some opinions for and against revoking the citizenship of convicted terrorists. I personally, as I said, stand firmly in belief that citizenship is predicated on loyalty. And if you seek to destroy the stability of the state through terrorism, you should not hold Canadian passport. Canadian passport is highly regarded. It is very, very highly respected. And here what we are talking about, I mean, I'm just shaking my head. We are talking about those few convicted terrorists who intentionally, knowingly use the Canadian passport to go to a third country, maybe go through all kind of training there, stay there for a few months or maybe years, then get involved in those gruesome actions against humanity. And I have heard from some witnesses proposing that they should still have the opportunity to stay in Canada and use Canadian passport, whereas they chose to go somewhere else. So, Mr. Collicutt, my question is this: that what is your view on the justification for revocation of citizenship for convicted terrorists?
On this specific question of revocation of citizenship because of involvement in terrorism, is that the question?
That's correct.
Mr. Shori? Yeah. Well, I think you summed it up very well. We're not talking about people who have been charged with terrorism in some country that doesn't have a good legal system, and I think that's taken care of in the bill. We're talking about the very obvious cases of people who have gone and got involved in very nasty terrorism operations. So I don't see the problem. Of course, if we started taking away citizenship from every Canadian that was charged with a terrorism act, say in Russia for activities in the Ukraine or in a lot of other places, we would have a problem. But I don't think that's what the bill's aimed at, and I don't think the bill will be misused for that purpose. I think the safeguards are there, and I think they make sense.
Well, let me share with the witness another thing, that we have learned some pretty disturbing news over the past few weeks. First, it was confirmed that one of the suspected terrorists in the gruesome bombing in Bulgaria is a Canadian citizen. And over the weekend, it was confirmed that now 2 Canadian citizens are alleged to be involved in the horrific terrorist bombing in Algeria. And a third and fourth may be involved as well. We have also learned from another committee, again a disturbing news, that many Canadians have been going abroad to commit terrorism, to commit terrorist actions. Do you think radicalization of Canadian citizenship is a growing problem, number one? And number two, do you think it is important for us to send a message to these terrorists who are Canadian citizens that their actions will not be tolerated and will be seen for what they clearly are, a violent renunciation of their loyalty to Canada and their citizenship, and that their citizenship can be revoked? Mr. Collicutt, I want to start with you.
No, I agree with you. I think that message has to be sent. I might mention that in 2006 I published a paper where I recommended people who are coming here to be naturalized take an oath saying that they won't commit a terrorist act. That particular recommendation wasn't acted on. But the issue of whether we have two-tier citizenship and treat naturalized Canadians differently from those born here, I think we do everything we can to make sure that doesn't happen. But I think there are some cases where there is a strong justification for telling people who may come here intentionally to get a base in Canada and get a Canadian citizenship to commit terrorism. I don't think there'll be that many cases, but there are increasing numbers where that's happening, and it's a serious issue. And I believe the safeguards in this bill are sufficient to see that it's not misused and abused.
Well, thank you, Mr. Colacott. I have some time, right?
1 minute, sir.
Thank you. Mr. Mattis, would you agree with me that the convicted terrorists should not have the ability to use a Canadian passport to travel overseas, where they may associate with extremist groups or involve themselves in terrorism?
Well, what I would like to see is perhaps you might even want to do this, make an amendment to the Act so that the wording of the Act would conform to your understanding of it. Because right now what the Act does is it sets an equivalence on the basis of offenses, not on the basis of acts. So your understanding is that if a terrorist act is committed abroad, it would be considered a terrorist act here. But what the legislation says, if somebody is convicted of an offense of terrorism and that the wording of that offense is an equivalent to the wording here, no matter what the act abroad, then the person can lose citizenship. And that's a problem. If it were an act rather than an offense, that particular problem that I was worried about would in fact disappear, because then we would look at the quality of the act rather than at the quality of the conviction or the absence of quality of the conviction.
Thank you, sir. Mr. Shore, I'm afraid that's the end. Mr. Mattis, one of my colleagues has asked if you were referring to some notes, whether you'd be prepared to make them available to the committee.
In fact, I've done so for the interpreters, and I've made, in fact, a few typographical corrections.
Oh, we don't mind those, or spelling errors.
You're welcome to have the version I already have, sure. But I could also email you a better version.
Okay, that would be fine if you could do that to the clerk, and she would have it translated for other members of the committee.
Sure.
Thank you, sir. Well, Ms. Blanchette-Lamoth, you have time for one question.
Oh, one question.
One question.
Okay. So, Monsieur Mattis,
Mr. Mattis, I have a question for you on the declaration of intention to reside in Canada. It seems that we've seen a number of different opinions on this. Some suggest that because of declaration of intent to reside in Canada, if the person does not reside in Canada, they could be accused, for example, of making a false declaration and see their citizenship revoked. However, the government continues to say that nobody's citizenship will be revoked if they declare an intent to reside, but they don't reside here after receiving their citizenship. What would your opinion be on this? Would it be possible, according to the wording of the bill, to revoke the citizenship of someone based on their declaration of intent to reside? Yes, I'll answer in English.
I mean, how the law is going to work out in practice, of course we have to see, but of course it's possible. And I have to, as a lawyer in private practice, I can tell you of an experience I see is, of course, many people who are citizens now come here as refugees, and then they get a permanent residence, and then they get citizenship, and then they go back for family or whatever. And I have seen cases where the government then proceeds to try to unravel all that through, first of all, revocation of refugee status, saying that they have re-availed themselves the protection of their home country. And after they win on re-availment, and they try to unravel everything. Now, often this happens in the context, the way I see it, of Canadian criminality, that they decide they want to deport someone for Canadian criminality, but it's too complicated because they need a public danger opinion, so they try something else. So what you do, I mean, you know, somebody just says something and maybe they'll leave most of them alone, but there are a few cases where they'll want to get rid of them for some other reason, and then they'll pick on this because it's easier than following through on that other reason, and that's part of the problem we see with once we set up powers. I mean, one would hope they won't be abused massively in every case, but there's always the potential, and the reality is it does happen.
Thank you, Mr. Matas.
One very brief one, if you want. Very brief.
Okay, super.
But it's got to be brief.
Madame Douglas, on a...
Ms. Douglas, we've talked about the fact that a Canadian, a second-generation Canadian, could be exiled into another country, even if that person has never lived in that country and does not know the language of that country. Ms. Douglas, Mr. Matas, do you understand that under Bill C-24, a person could theoretically be exiled into a country where they have never resided and where they do not know the language? And in your opinion, is that fair? Is that an appropriate way to say that according to the origin of your parents, you'll have this particular sentence?
It's not fair at all. It is the same concern we have with that allowance under IRPA, where because you commit a crime and is given a sentence of more than 6 months now, with the changes, you're able to be deported to a country you may not have any connection to because you happen to be born there. The same thing with the Citizenship Act, that because of dual citizenship, you may be able to be sent back to a country that you have no connection to. It is unfair, and as we said, we really are creating two-tier citizenship, and I don't think that as a country that is what Canada is about.
Thank you, Ms. Douglas. We'll give you the last word. And I thank you and Mr. Matas and Mr. Callicott on behalf of the committee for coming and giving us your thoughts on this bill. Thank you very much. This meeting is adjourned.